client's attorney. That would be something similar to legal aid. So they're going to make it available for these nonprofit legal services to represent the client, because this is a civil process, not a criminal court process. And only in the event that there is no one to represent the client would the public defender get appointed. Okay, kind of moving over, up to that top thing, the court will look at the reports that have been placed into the court, and the court will then has three options, right? It looks like the client meets criteria for care court. The court has three options, and I'm having a hard time reading this, so I'm going to bring out I have mine printed out. So within 5 days of receipt of the report, the court will review the report, and the court, if the client meets criteria, and the client is willing to voluntarily engage and actually signs up for behavioral health treatment, then the case will be dismissed. It won't go any further because the client has enrolled in treatment. If the client meets criteria but is not willing to engage voluntarily in treatment, then the court will set a hearing 14 days out, and then they will have a hearing on the merits. So then at that time, the client can come forward with their attorney and say, hey, I don't think you say I meet criteria, but I don't really think I do, and let's have a hearing about it. If the client does not meet criteria as a result of that report, the case will be dismissed. So I'm going down that middle section there where there was the hearing set. The client meets criteria but is not voluntarily engaging. They will set a hearing within 14 days, have a hearing on the merits of the case, and determine have the court actually make a finding that the person meets criteria or not. The person does not meet criteria at that initial hearing, the case is dismissed. If the client meets criteria, the court will order the Department of Mental Health to meet with the client and the client's attorney to see if a care agreement or a care plan can be done. So is there agreement about a care plan? If no agreement can be made, then you're going to move over, and Araceli, if you can move over to like the no agreement move over a little bit to the side there. And you guys, you have this in my presentation, so you can look at it a little bit closer. If there's no agreement that the client, the attorney, and the department can come to, then the court will order a formal clinical evaluation. And as part of this evaluation, they're going to talk about whether or not the client has capacity to say no. Is this appropriate, or should they be involuntarily placed in the program? There will be an evaluation review hearing, and at that hearing, they will determine, yes, the person should be placed involuntarily into the care program or not. And if there's no evidence to support that, the case would get dismissed. If there is evidence that the person meets criteria and should be placed in this program involuntarily, then again, the client will be ordered to work with the Department of Mental Health and their attorney to develop a joint care plan. So the first attempt is voluntary. Can we get everyone to voluntarily agree to participate in this program and come up with a care agreement? If we cannot get individuals to voluntarily participate in it, then it becomes an involuntary treatment plan, and the client is court ordered to participate in coming up with a care plan. So you will hear care agreement and you will hear care plan. Care agreement, everyone's on the same page and willing to work together. Care plan is the involuntary process where the court has ordered the client to participate in the care plan process. That would then trigger your 1-year plan. So this process will be 1 year. And then there will be status hearings every 60 days. So even if the client agrees to the care agreement or disagrees, both of those processes lead to a care plan or a care agreement, which establishes your 1 year start date. And then there are status hearings every 60 days to see how the client is doing. If the client is doing well, at the 11th month status hearing, there are a couple of options. The client can request to graduate from the program. And if they request, the court would order a graduation plan be developed that would determine what would be the ongoing treatment plan for the client. The client can elect to be reappointed for 1 additional year. The maximum amount of time you can be in the care plan process is 2 years. That's the maximum amount. There is also the possibility that the court could say, I'm going to place you 1 more year in the involuntary process. I don't have that on my spreadsheet or on my diagram, but you could be involuntarily continue in the treatment for 1 year. But if at any point in those status hearings, the client is failing and is not doing well in the care court process, the court can order the Department of Mental Health to do an evaluation about whether or not the person is a danger to self, danger to others, or gravely disabled. So there is the possibility, if there is failure in the care court process or the care process, that a person could be referred to the public guardian's office for conservatorship. I know that's a lot of information. Right now, I just want to let you guys know that this is out there, and that we anticipate this is going to be signed into law, and that this might be a process we're going to have to spend a lot of time teaching people about, but we will have a whole year to do that. Next slide. Involuntary, these are the reasons why somebody could continue on an involuntary process for 1 year, the reappointment involuntarily. I won't go through them. Next slide. This tells you what the care plan must have. So there are elements that are required in the care plan around the services that will be provided, what housing resources will be offered. Let me make it clear. There is no requirement to house an individual who will be part of care plan. We have to offer housing. We have to say what housing is available, but the court cannot require the county to provide housing. Clients should be prioritized for housing, but it's not going to be a requirement to be housed as part of this process. Medications can be court ordered, but cannot be forcibly administered. So there will not be any forced medication, but the court could order a client to take medication. And I'll let you guys, that pretty much sums that up on that slide. So let's go to the next one. The role of the supporter. For those of you that have been tracking this legislation or who heard my presentation the last time we did this training, one of the elements that was in the legislation then that has been modified is about the supporter. Originally, the state was going to provide a supporter, a trained supporter, a paid supporter that would be assigned to every client that was in care court. That is no longer offered. Now, if there is a supporter, the respondent or the client themselves must advise the court they have a supporter that they want included in the process. And if there is a supporter, they get to participate in those meetings around the establishing of the care agreement, the care plan, all the court hearings, all of that. But it's not an automatic anymore. The client would have to bring forward that they have a supporter that they want. If there is a voluntary supporter, they will be able to get training from the state. There will be a training program for volunteer supporters. And the supporter is really there to help the client be able to articulate their decisions, to be able to voice what kind of treatment or services that they want, and help them participate in the process. But the supporter cannot speak for the client and cannot direct anything. They are there to help the client understand how to make decisions and how to voice those decisions and be an active participant in the process. Next slide. And then there is some accountability. So if the client is failing to participate or failing to comply, the court could terminate their participation in care court, or we might see something around a possible referral for conservatorship. Failure to successfully complete care court may be a fact that the court can consider in other hearings. So if in the scenario that somebody fails care court and they are referred for conservatorship, the court can take that that fact into evidence, and they can use that to determine whether or not the person should be conserved. So there is that possibility that the fact that you have failed in care court may be used as evidence in the conservatorship, but that has to happen within 6 months of the failure in care court. If the court finds the county is not doing their job in making sure that they get treatment and services, that we have not, managed to do what we said would be in the treatment plan, the county or the department can be fined $1,000 per day, not to exceed $25,000 per client. That money is going to be put into an accountability fund at the state, and that funding could come back to the county to be used to help improve service delivery. Repeated noncompliance by the county could allow the court to appoint a receiver, which would mean that the receiver would then determine and tell the county what to do regarding services for that one particular individual. Next slide. Let me go back one, Araceli. Let me just say that right now, there is no additional funding coming to the Department of Mental Health for this care court program. There are negotiations for some funding, maybe around the court process, but right now it is expected that the county departments of mental health and behavioral health will utilize their current funding resources to take this on. That is a serious concern to the department, particularly, at a time that there are a lot of demands on the department. And we believe that this will introduce people that we probably have not been serving in the past. So it will be an additional population that has not been getting services from the department for whatever reason, that we will now have to find funding for to provide services. So that we are in the process right now of looking to see to what extent we can use funding for this, and can we absorb what we think is going to be a lot of petitions filed by the court and potentially a lot of candidates that will be eligible for care court. Next slide. This is the courthouse information. The courthouse is open. Masks are strongly encouraged. Initial hearings, the initial conservatorship hearings are generally being done by WebEx. Court trials on a case-by-case basis may be WebEx or in person. Jury trials are always in person. Next slide. This is the contact information for the public guardian's office, so that you are, there's a general line that you can call. You can see all of the management staff that's available and who you can call. And I think I've hit the end of my presentation. And I think what we'll do, Gail, is reserve questions until the end, because I'd like Linda to be able to do her AOT presentation, and then I'll be available. And I'll answer, I'll help on the chat too if there's something.
Thank you, Connie, so much. Appreciate it. Did we lose Linda?
Where's Linda?
She might be on mute.
Okay, let me.
I'm right here.
Oh,
Right here.
hey, Linda.
How are you?
Well, we're good. Thank you.
Okay.
It's your turn. Go ahead.
And I'm just waiting for her to bring up the presentation. But in the meantime, just let me say that there are a few non-LPS designated hospitals in LA County, and I've gotten phone calls from folks whose loved ones are in one of those hospitals, and they're not understanding why they've not filed for conservatorship. So Bellflower Hospital and Southern California Hospital of Culver City and Van Nuys are not LPS designated facilities. They're voluntary only. And so if a person goes into one of those three hospitals, and Connie, there may be others that I'm not aware of. I know of those three. So when folks go in, even if they're kept for a long time, they're voluntary. And so they can't be conserved out of those hospitals.
But those are not involuntary hospitals, are they?
No, they're voluntary. They're totally voluntary.
Yeah, they have to. Yeah, Cedars-Sinai is one too that's voluntary.
But they don't have, Cedars doesn't have a psych unit anymore, so they're not LPS designated. They're,
No, they're voluntary totally for whatever they do, which
they
isn't
don't have
much.
they don't have a psych unit anymore. So they're
Okay,
in the ER, the doctors can put someone on a 5150. We have some hospitals medical hospitals that were given permission to put clients on a 5150 if they met criteria, and then they have to transfer them out.
okay,
The Salience is closed with Cedars. They don't have any
right,
psych, yeah.
okay,
And so when I'm going through, good afternoon, and it's a pleasure to be here with everyone. And as I'm going through this, you will notice that there is a lot about the AOT criteria. You'll recognize a lot of it from which Connie, the similarities between what Connie just presented with the CARE Act, or as we all call it, the CARE Court. A lot of similarities with Laura's Law or the Assisted Outpatient Treatment Program. Next slide, please. So Laura's Law was named after Laura Wilcox, who was volunteering in a mental health clinic. She was in college volunteering in a mental health clinic during her, when she was having summer vacations through college. And when she was volunteering during her winter break, someone came in who had been non-compliant with treatment and killed her and injured another person in the clinic, went to a restaurant and killed someone in the restaurant and injured someone there as well. And her family fought to have treatment for folks who are non-compliant with treatment. So in the Project Act of 2002, which also was the Bill 1421, which also added 5150.05 to the Welfare Institution Code, saying history shall be considered, the AOT demonstration project was formed, and that became known as Laura's Law. It's based on Kendra's Law out of New York. Go ahead, please. So the Laura's Law, or AOT, allows the Department of Mental Health to serve seriously ill folks who are at substantial risk of deterioration as a result of poor psychiatric treatment compliance. And we use two forms of treatment in AOT. We refer people to full service partnerships, and Connie mentioned those. They're programs that have the motto of whatever it takes. So they visit the client in their home, on the railroad tracks, in living by themselves and living in SRO, wherever the client is at, and they offer treatment, and they have 24-hour crisis services available. And the other program that we use are enriched residential service beds, which were formerly known as IMD step downs. So these are facilities where there's kind of one-stop shop where the person gets their medication, they see a psychiatrist, they have group therapy, they have individual treatment, and they live at the facility for the most part. And those are the two forms of treatment that are provided through AOT. None of what AOT has to offer is locked. Both of these are unlocked programs. AOT, they're at full service partnership, they're living at home, they're living wherever they're living. And in the ERS, they live in a specific boarding care where the ERS goes out to them, or we have a few that are on site where everything is provided on site, including the housing. But everything we have is unlocked. Next slide, please. So if a person refuses services, we can petition in mental health court to have court ordered mandated treatment provided to that person. And then what AOT has allowed us to do is it expands our interagency collaboration. We deal with county council. We have a county council person assigned to AOT. We have a public defender assigned to AOT. We work constantly with patients' rights, law enforcement, other mental health agencies. So we've really expanded for outpatient treatment, because Connie and some of our other programs have dealt with the court continuously. But for outpatient programs, it's expanded our interagency collaboration with partners that we didn't have in the past. Next slide, please. So this is the eligibility criteria for someone to be a part of AOT, and you will notice there's some similarities with the CARE Act. A person must be 18 years or older, have a serious mental illness. Unlike CARE Act, it can be any serious mental illness. So major depression, bipolar disorder, as well as the schizophrenia spectrums, PTSD. It can be any DSM-5 severe mental illness is categorized in the DSM-5. Have a history of non-compliance with treatment that has resulted in they've either had 2 hospitalizations in the last 36 months or 2 forensic incarcerations, such as Twin Towers, where it's not just that they've been taken to a local jail, but they've been placed on a mental health unit in jail, or they're receiving mental health services in jail, or in the last 36 months, or our county council person says they could have one of each. They could have a hospitalization and they could have been in Twin Towers, one each in the last 36 months, and that does count. Or they've had a serious threat or attempt to harm themselves or someone else in the last 48 months. And here again, we're like Connie, I'm going to be a little different than from what Gail said. For the purposes of our program, in order for us to have the person get treatment, if your loved one hasn't been hospitalized, but they have been violent, we need to know that, because that might qualify them to be a part of the AOT program. If they've not had any hospitalizations in the last 36 months, they've not been in Twin Towers or another mental health unit of a jail in the last 36 months, and they've had no acts of violence or threats to cause attempts or threats to cause serious harm to themselves or others, just by statute, as you can see, they would not meet AOT criteria. They have to be substantially deteriorating, or they have to be, or the same as with care team, AOT is needed in order to prevent a relapse. They have to be unlikely to survive safely in the community without supervision. They have to have failed, and then they have to be non-compliant or failed to engage in available treatment. And so this is where it's a little different as well from care court that you just heard about. So for us, if they're seeing a psychiatrist every month, but they're not doing anything else, the fact that they are engaging in treatment, they will not qualify for AOT. And we often have folks who are seeing a therapist, but they're not taking any medication. The Act, there is no mandatory medication with AOT. The judge does tell them that they're ordered to take medication, but there is again no involuntary medication for them to be able to be treated involuntarily with medication for AOT. So if they're getting services with the full service partnership, but they're not taking medication, or they're seeing a psychiatrist every month, and they are taking meds, but they're not doing anything else, and they're not getting much better, unfortunately, because they are in treatment, they're not going to qualify for AOT. And then they have to be likely to benefit, and AOT has to be the least restrictive treatment available for them in order to recover. So you can see that many of the criteria and eligibility for care court was taken from the AOT statute. Next slide, please.
Linda, can I interrupt real quick? If I can just interrupt. When you're requesting AOT, you can also, at this time, if there's a substance abuse problem, you can mention that with AOT. But when they're in the hospital will tend to discharge. So AOT, you can let them know, because they will be treating for that too.
Right, right. And just as an aside, in the hospital, most of the time hospitals do tox screens. They do toxicology screens when the person is admitted. So if a person has substances on board, the hospital tends to know that right away. Mm-hmm. So what we provide is extensive outreach and engagement. I call it aggressively hanging out, for a minimum of 30 days. We do screening and assessment. We link to, so if a person comes to us and we outreach to them and they say, yes, I will accept treatment, we have them sign consents, and we assign them to a full service partnership. We have some special AOT full service partnerships that we assign folks to. And then, and if they say, we still keep them as a part of AOT, but once we have linked them to that full service partnership, the full service partnership takes over with treatment. Or we will link them to an ERS. If the person says, yes, they're willing to go to an ERS, we will link them to an enriched residential services bed. If the person, we're outreaching to the person and they're not complying at all, they're not willing to get treatment and they continue to deteriorate, or we know they're going to relapse without any help and they're not being able to survive safely in the community, we may petition the court to order psychiatric treatment. And then we participate in the follow-up and the court mandates. Next slide, please. So I'm just trying to close the windows. Sorry. So who can refer? So again, this is much like what you saw with Care Court. A roommate over the age of 18, a close relative, and that is defined for AOT statute as a parent, a sibling, a spouse, or an adult child over the age of 18. Now, if we get a call from a grandmother and the grandmother has been the person who's raising that child, then we consider that a parent. We've gotten calls from aunts or uncles, and really more aunts, who are the only folks who are in that client's life, and they've been in that client's life forever, and they're the ones who've been trying to get them care and have been directing their care for years. We consider that a close relative. So some of that can be on a case-by-case basis. The director of the client's residential care facility or a hospital director, a licensed mental health treatment provider, a peace officer, a parole officer, a probation officer, and as of July 2021, the judge in the Superior Court. They can all refer to AOT. And so it doesn't, for us, it's not a fire, first responder, not fire. It has to be police, parole, or probation who does the referring. And for the police officer, it can be one contact. It tends to be that they also are encountering this person multiple times. But those are who can refer to AOT. Next slide, please. So when you're looking at the AOT process, if you look at facing this, the upper right-hand corner, we receive an AOT referral. And then my team gathers all the information and we meet every Tuesday afternoon, and the cases are presented to a referral review team. When we first started out, Patients' Rights was a part of that team. My staff, I have psychologists, I have social workers, I have psychiatric technicians, community mental health workers, medical caseworkers. We review the referral to make sure that it meets AOT criteria. We will talk to the person who made the referral. Sometimes our psychiatric mobile teams make the referrals, or our law enforcement teams. And in those cases, we often will talk to the family as well to get more information about the client and what they're doing. And to make sure to see, sometimes PMRT doesn't have all of the information. And when we look at the referral from them, they don't quite meet criteria. But when we talk to the family, we get additional information and they do meet AOT criteria. And then if they meet the criteria, we start to engage the clients. So our outreach and engagement team, which are directly operated DMH staff, go out and they see the client, they offer services. We do everything we can to get that client to engage in services. We also have CAL cards, which are credit cards, so that we can buy food, we can buy clothing. If they're going to be linked to services and there's housing available, we can put them up in a motel for a few days until they get linked to that particular service. If they refuse, then we can petition in mental health court. Actually, it's Department 103, the same department that has where the conservatorship hearings are held. And then as a result of whether they're petitioned or not, intensive outpatient mental health services are offered. Next slide, please. So let's talk a second about the petition process. So with the petition process, so this is all by statute. So our outreach and engagement team go out several times, and it's usually more than 30 days. If we believe that the client might say yes, we always want people to volunteer, because that tends to be, if they're more engaged, they're more willing to follow through. If the client does not, if we have clients who tell us pound sand, or who will talk to us only as long as it takes them to finish the pizza that we've bought them. And we go back weekly to see the candidate. And if they say go away, we go away and we come back the next week. The one thing that's different about AOT is that we do not give up. We don't just stop. If the patient sends us away 100 times, we go 101 times. So in other times, full service partnerships can say the client's refused and we've been outreaching for 45 days, we can close the case. That does not happen with AOT. So once the team decides that this client is not going to engage and that they are deteriorating and that they do need to be petitioned, our psychologist goes out to evaluate the client. She offers them a treatment plan. This is all by statute. Then within 10 days of visiting that client and offering them a treatment plan, she writes up a declaration and submits it to county council. And the declaration or the affidavit just talks about the 9 criteria for AOT and how the person meets each of these criteria. And then county council draws up the petition. It's sent over to Department of Mental Health. Dr. Bonds has been signing those petitions, and we send it back to county council. County council files the petition with Hollywood Court. A hearing is set within 5 days of the date the petition is filed. The hearing is set. Next slide, please. So what happens when we get to court? So we have a public defender who tries to go out to see the client before the court date. And so the client will go out and the public defender goes out and talks to the client. At that time, the public defender will ask the client if they would like to submit and be a part of AOT without having a court hearing. And if the client says yes, then that's called a settlement agreement. And that looks like it very much correlates to the care agreement, what would be with care court, the care agreement. So the person submits to being a part of court-ordered AOT. If the client says, no, I don't want to be a part of this, I don't care, then a hearing takes place. And much as the way Connie described the court process, for her, the court process is very similar for us. So the person can be on WebEx or the person can come into court, and it's up to the client. The AOT also, the statute also allows that if the client does not want to come to court and we have properly served that client, that we can have the hearing in absentia, that the client does not have to be at court or participate in the hearing at all. So let's say the client does come on WebEx. We will, our county council swears in our psychologist, she testifies. So if the application or the referral or the petition is based solely on threats, so your loved one assaults you or threatens to kill you, and they've had no hospitalizations, and so the petition is based solely on threats, we do need to have someone testify as to those threats, because Connie mentioned the Sanchez rule, and that applies for AOT court as well. So our psychologist cannot testify that mom told me that the client pushed her and knocked her down. That's hearsay. So we are very reluctant to have family members testify, particularly when there's a risk, and we also realize that your relationship with your loved one is critical and is very necessary for you to continue to support your loved person. So what we will do when it looks like it is going to be detrimental to the relationship or detrimental, or it's going to create more risk, is that our county council will talk to you on the phone, get a written testimony from you, will present that to the public defender. The public defender will vet, yes, that she believes the statement. She may call and talk to you herself. And then we give that statement to the judge, and then the judge reads the statement. So it's entered into evidence through a written statement as opposed to active testimony. There are other times where family members say, you know what, I want to testify. I want to be able to to tell the judge what's happening and how much is going on in our household. The other thing that happens with every hearing when a family member testifies is that the testimony always ends with, tell us something positive. Tell us your loved one's strengths. Tell us what's happening and what your loved one was like and is like. And families, when they start testifying to what their loved one was like before the mental illness became so severe, has the whole courtroom, often all of us, in tears. Your statements are not only are they heartfelt, they're vitally important, and they carry a lot of weight. And how much you love your child, and how, for the most part, it's children, but it can be your mother, your aunt, your sister, your brother, how much you love that person, and what kinds of strength that person possesses and will be able to possess again when they're in recovery, is it's heartfelt from all of us, not just from you telling it, but from all of us hearing it. So it's critically important. So the family member will testify if that's necessary. If it's based on hospitalizations, then the family does not need to testify. We go by the hospitalization and hospitalization records. And so then the psychologist will testify to all of the 9 criteria. Our county counsel asks them, the public defender cross-examines, and then if the client wants to testify, the client is sworn in and they testify, and if necessary, county counsel cross-examines. It's a very supportive court, even though it sounds like it's the same as a criminal court. The elements are the same, but the feeling and what goes on inside court is very supportive. And then the judge rules, and the evidence is clear. The legal standard is clear and convincing evidence. And if the judge orders whether the person has signed a settlement agreement saying that they go ahead and they will submit to the court-ordered AOT without a hearing, or whether the petition hearing takes place, the person is, if the judge sustains the petition, the person's ordered for 6 months at a time. We will bring the person, we were able in the past to be able to bring the person back to court as often as necessary. And sometimes it would be weekly until the person really understood that it is a very serious process, even though it is a very supportive process. The court calendar is such now that we're not able to bring them back that frequently. The statute said they must come, same as with the CARE Act, every 60 days. We bring them in more frequently than that, because we find that if people are doing well, the praise that they get from the court and the support they get is meaningful for them. And if they're not doing well, excuse me, having the judge and the public defender and county counsel talk to them about and encourage them to continue to keep trying and to hang in there is also very valuable. At the end of the 6 months, if the person still is not complying, or they're going to be relapsing without this, then another petition process takes place, and it can be extended for another 6 months. We have had people who've been in the program for 2.5 years, who've been court ordered for 2.5 years. Next slide, please. Again, as I just said, the court orders are in 6-month increments. We monitor and advocate for all aspects of treatment, including the medication. And so the judge will say, you know, you're ordered to comply with the program, including medication, if that's what the treatment provider has believes is beneficial for you. But there is no forced medication. And the black robe effect. So if a person respects the judge, respects the law, AOT can be extremely successful. If the person doesn't respect the judge, doesn't have any respect for the law, then it's not as successful. And I can say that the biggest obstacles we have, and the biggest obstacles that most programs have, is the anosognosia. When someone doesn't believe they have a mental illness, that creates issues. And for someone who doesn't believe they have a mental illness and is also abusing substances, that also creates obstacles with our program. Our judge has ordered inpatient drug treatment or residential drug treatment. We can't force anyone to do that. We know that all drug treatment is voluntary. And we have had success where the judge ordered it, the person believed that they had to go because the judge ordered it and they went and they were extremely successful. We also have had a person who was really dying from an eating disorder, and the judge ordered an eating disorder inpatient stay for them, and the person said yes because the judge ordered it and is doing very, very well now. Next slide, please. So again, whether they're court ordered or whether they're completely voluntary, a person is assigned to a full service partnership or an enriched residential services provider, and the treatment begins. And the progress reports are sent to court. So if we have court every Friday, and so if the person has court on Friday, the calendar goes out on Monday, and the providers send progress reports by Tuesday night. They're submitted to the court Wednesday, so the judge has all of the progress reports, as does the public defender and the county counsel and I as well. And we all read them. We read every single report, and so that we know what the client is doing well with, what the client needs help with. If the providers want the judge to say anything special to the candidate, to the client, then that is also put in the report, and we stress that so that the client, if they're complying with treatment, it was really difficult for them to start. We heap lots and lots of praise on them to continue. And if the client's not doing well, then particularly the public defender and our county counsel will really strongly try and encourage the person to comply a little more and to help them become more engaged in the process. Our public defender does go out to see the client during their 6 months in treatment with us with the court ordered part. So she continues to reach out. She has a social worker who's assigned to her, and they go out together, and they constantly are in constant contact with both the client and the family, and all three, I should say, the client, the family, and the provider. So all of us work as a team to provide the clients with whatever they need to help them to be successful. If a client refuses to be examined, and the law just changed a little with this, we can ask the judge to order a hospitalization order so the hospital can determine the 9 criteria for AOT, and that's a 5346D order. If a client is in the full service partnership or ERS and they're non-compliant with treatment and they're not doing well, then we request a 5346F from the judge, and that gives us the ability to hospitalize the client into an LPS designated facility, and that person then will be evaluated for a 5150. For the most part, by the time we get to a 5346, most of those clients meet 5150 criteria as well. So when we go out to execute the 5346, we also put that person on a 5150. And but by statute requirements, they could be what I sometimes call a 5149 or a 5149 and a half. Their behavior does not have to rise to the level of a 5150 in order for them to be taken to the hospital to be stabilized. It's just that our hospitals are so overwhelmed that for the most part, if they're not meeting 5150 criteria, the chances are they won't be kept very long. The other thing that was happening more with before COVID is that we would have graduations. So when a person completes the 6 month or the year or however long they are petitioned, when they've successfully completed and they're being stepped down to a regular FSP or to outpatient services, we have a graduation. So we bring their favorite flavor cake, cupcakes. We have a card for them. We have $25 Target gift cards that we give out. The judge comes off the bench, shakes their hands, takes pictures, everybody claps. It's a big deal. We have graduation is a big deal. And so we want to acknowledge the person's success. And they've had a lot of support, but that person did it. They have succeeded. They have done what they needed to do to improve and to be on their road to recovery. So it is a big deal, and we make a big deal of it. Next slide, please. So just when you're looking at it, there's involuntary treatment, which is, criminal, civil, LPS, conservatorship, and then there's very voluntary at the very bottom. And then if you click it again, Araceli, then you see where mandated treatment comes in. So it's the most restrictive outpatient treatment that we have. But again, it is all, it is outpatient. There is nothing locked. But it is more intensive treatment than some of our other outpatient programs. Next slide, please. The other thing is that, a lot of our clients have had forensic involvement, but many of our clients have not. So with AOT, you don't need to have been in jail. You don't need to be in part of the criminal justice system to be a part of AOT or to even go through our petition part to have us mandate outpatient treatment. So hopefully for a lot of folks, we can engage them in treatment before they do anything that would bring them to the attention of law enforcement. We monitor the compliance for the 6 months, and again, for much longer than 6 months for most folks. We're decreasing violence and the criminalization of folks who have a mental illness. And the history is relevant to what's happening. And you can hear for a lot of programs, the history is relevant, but when they get to court, sometimes what's happening that very day is the most relevant. With AOT, it is all predicated on the history. And so, so history is the main factor in, and usually if they have the history, they're still not complying now, which is why we are petitioning. If we're in the petitioning process and a person becomes engaged with the full service partnership, or goes to see a private psychiatrist, whatever it is, if they engage in treatment while we're setting up to petition that client, we don't follow through with the petition. If the person voluntarily engages, we stop the petitioning process. And then we intervene before a 5150 hopefully is necessary. But again, given the situation and the crowding of hospitals and the situation in LA County, most of our clients also do meet 5150 criteria. Next slide, please.
Could you interrupt just for a second? Araceli, Gail was some reason bumped off the program. She's trying to get back in. Thank you. Go ahead, please. I'm sorry.
No problem. So this just lets you, you see that they're at the center circle, the consumers are in crisis, and then there are clients on the outer circle who are very compliant with treatment. They're not going to qualify for AOT. And then there are consumers who are not compliant with treatment, and those are our folks, as I like to say. Those are our folks. And AOT is necessary to prevent deterioration that's likely to cause danger to self, danger to others, or grave disability. Next slide, please. Our fax line has changed, but our the general line, you see the general line 213-738-2440. If you, and that is our email, but if you Google AOT LA, assisted outpatient treatment, Los Angeles pops up. If you click on that and go to the end, to the bottom of that page, you will see it says new referral form. You can fill out that form, and at the top of that form, it has the email address. So you can just email it to us. And I can say for folks who have private insurance or for folks who have Medi-Cal, those hospitalizations do not show up on our electronic records, on the Department of Mental Health electronic records. So if you're referring your loved one and they've been hospitalized, but they've been with Kaiser, or you have private insurance, or they have Medi-Medi, then please, if you have any documentation about that hospitalization, we do need that. If we're going to petition the client, we need to be able to present that to the court. If they're straight Medi-Cal and they've been hospitalized, that's generally in our system. but folks with Medicare are not, the hospitalizations are not in our system, and the private insurance is not in our system. We've been talking to our county council, and he's willing to subpoena the hospitals, because for us to call the hospitals to get records does not happen. And so we're going to start to try and petition the hospital, subpoena the hospitals for those records. But if you have discharge summaries, anything from those hospitalizations, it would be very, very helpful for us. And so that if we do need to petition, we have that information readily available to be able to do the declaration. So next slide, please. Any questions at all?
Can I ask a question?
Oh,
Sure.
or
My son is on the AOT, and you mentioned a team. I only seen one person trying to approach him. Who were the members of the team?
I'm not sure. So I believe for your son, it is Rick and Jim.
Jim.
And Rick is his partner. So you may be seeing and speaking mainly to Jim, but we go out in pairs. So
Okay.
yeah.
Um,
Go
so
ahead.
Lisa is here, correct? So before we jump into Q&A, which thank you, we just wanted to give her segment.
I think that's a good idea. Okay, Araceli, are you going to introduce Dr. Lisa Wong? Because I think you have her, I think I gave you her.
I believe she's
Yes.
here. Yes, I will put up, yes, I will pin her. I can.
Okay, is she on?
Yes.
Oh, okay.
Hi, Gail.
Hi. Hi, Dr. Lisa. Thank you so much for doing this for us. I appreciate it an awful lot. You've been sitting and listening to quite a bit. So thank you.
Well, it's an honor to be here, and it's always great to listen to Connie and Linda because they're such experts in their fields. I feel like I always learn something listening to the two of them. We're very lucky to have them in the department. I mean, I think if I had a loved one who was very high acuity, they are the experts that I would want to turn to. And also Luis Leyva as well.
Yes, yeah. We have a good team in DMH, people that really can solve problems, and I'm thrilled. So for all of you who are listening, Dr. Lisa Wong is our new acting director for DMH, for Department of Mental Health. This lady is quite amazing. She's worked in downtown LA, am I correct about that? With the homeless. She's worked with a whole lot of different vulnerable and high-risk individuals. She knows what she's doing, and I think she's going to lead us in a good direction. So I'm going to let you go ahead because I'm sure you have plenty to say to us. Steve Nazarian.
Oh, I don't know.
Oh, God.
He may be tired.
Hold on. They say they're done.
I think some people need to mute.
Oh, great. Thank you for that very generous introduction, Gail. And I guess I should start off by just saying that coming into this role as the acting director, I really want to emphasize that DMH is very committed to serving our highest acuity, most vulnerable populations above all else. And I know that Dr. Sharon had been very passionate about this and was very committed. And I assure you that commitment is not going to wane. You know, having spent over 2 decades in Skid Row, I saw what happened when the system fails and when people lose connections. And I hate for that to happen to anybody that we know, let alone our loved ones, our family members. Gail was kind enough to share with us just the other day a success story. And, you know, that's not often the case. We don't often get sent the success stories. We usually hear about, things when they go sideways. But it's really nice to have that success story, because that's what sustains us, knowing that what we do actually makes a difference, that people do get to the other side, that, there is hope for everyone. But one thing that's really evident, I think, in this success story is about a young woman who has been med compliant, who is, making strides in her educational goals, who is connected with her family. I think one thing that we all realize is that there is not one single component that can bring about this kind of success, right? I mean, Gail, as amazing an advocate as she is, Gail couldn't do it by herself. As amazing as Linda Boyd is with AOT, they can't do it by themselves. No matter how wonderful a parent you have involved or how committed a client, it takes all of us working together. There is this interconnectedness, I think, that we have to acknowledge and that we have to rely on and build upon. One of the people who has been most influential in my thinking is the late Archbishop Desmond Tutu. And in an interview where he was talking about how he was able to help stand up the Truth and Reconciliation Commission post-apartheid in South Africa and, really practice restorative justice, people asked him, what was his secret? How could he do this work in the face of so many obstacles? And he said basically that it was because he knew deeply that the better he was, the better the person next to him would be, and the better the person next to that person would be. That as human beings, we are all interconnected. And I think that's true on a systems level as well, because I'll tell you that the better DMH is, the better our clients will be, the better our families will be, the better our communities are going to be. And I think going forward, we really have to pay attention to that interconnectedness. We really have to partner in the efforts that we put forward to care for our most vulnerable in our system. So with that, I just want to thank everybody for coming today and to learn more about how we can care for our most vulnerable. And just want to renew our commitment to working together as partners as we go forward.
Did we lose you?
No, I'm still here, Gail.
Oh, okay.
that's
I was a little worried.
No, that's all I have. I'd like to open up the time though for questions, because I'm sure that there are a lot of questions that people have, whether it's about, the plans for our department or whether about specifics on conservatorship or AOT programs.
I'd like to ask a question if I could.
Sure.
Okay, what is your vision? Well, let me just back up. When I first started the LPS program, and it just kind of blossomed, it was not something I had planned, it just kind of did its thing. I took a survey right at the beginning, and it wasn't like one of those monkey surveys. We asked specific questions, and we found that within 6 months of somebody being placed under an LPS conservatorship, and we did not discriminate who was going to be. If family came, the first 28 people that came, we logged and we followed what they did. Within 6 months, 60% of the people had jobs or were volunteering or going back to school. And the recovery was so quick, because I wasn't going to do this if I didn't feel like people were successful. And they were. Because it's a lot to keep track of everything. I kept as best I could, but then it kind of had to go. I'm a strong proponent of LPS if a person has the gravely disabled, but I hate to see them decompensate so low. If they don't have reasoning ability, I like to see them go forward. I would like to see a continuum of care, that you have a person who's maybe an AOT, then they've done their time, they've graduated. All of a sudden they can't get the medication, or something else has occurred. It is extremely difficult. People with mental health hit all these obstacles. And as a family member, we're helping them. Let me tell you, parents call up and they are stressed. How do I get this? Their doctor's gone. You know, they were on a full service partnership, their doctor's gone. And we're talking about putting in all new programs. Where are y'all getting all the people to do all this? It's not possible. What I'd like to see is a continuum of care, and for the most vulnerable, the people that need LPS, to encourage a county hospital. I know we do have Augusta Hawkins, but a county hospital that will initiate LPS conservatorships, because it is the quickest way to get the person back their life. That's what I'd like to see, and an IMD with quality treatment, not just medicating the person, sitting them in the corner and letting them drool, working to give them medications to get their lives back. I've seen people I sent y'all the one about the one recovery. Get those a lot. I'll send you more. But basically, to get the people on the road to recovery as fast as we can so they can get their life back. Do you have a vision of something like that?
Well, I think an important component of that, Gail, is to build flexibility within our system, right? Because one of the important things you mentioned was that sometimes people get better and then they'll have a setback. And we have to have things in place to catch them at those times and not let them decompensate to the point where they're really back, maybe where they started or even worse. So I think one of the things we have to do is realize that we need to build a system of care that is not just levels, but there should be some degree of fluidity between the levels, so that if you graduate from, let's say, FSP, for instance, and then you're not doing well, you shouldn't go back and have to go through the whole process to get back into FSP. You should be able to, flow between levels of care more easily than that, so that we give people the appropriate level of care rather than the program they're assigned to or the funding source that it's tied to. So I think we're really working at the state level to do that too, so that we have a consideration of what's the most appropriate care for this person at any given time, rather than are they an outpatient or are they an FSP or are they a PEI client. I think we've made some strides in that area, but I think we still have a ways to go. And fortunately or unfortunately, that's also tied into payment reform issues, where we're not like doing this like per minute, per service billing, but that we're really resourced to care for a population and look out for their well-being across the board.
Thank you. I hope so. If there's anything that we can do, let us know. And that all of you folks that are listening, you guys got to vote. You got to find out who you're voting for and make sure that they're working to help those with mental illness. You would be surprised how many people get in office who are awful, and they only had a handful of people voting for them because people don't vote. You have to do that. And contact your legislators. Let them know. Lisa, tell us what you need. We can do it. We'll do it. If you tell us what you need, we will get on it right away. Seriously.
Well, we will definitely tap into that source of advocacy, Gail, because we need all the help we can get.
I know.
As Connie mentioned, with the care
court.
No, whatever the new name is, formerly known as care court.
Care process now, I think is
care process.
Care Act, care process. Yeah.
With that coming up, we are very concerned because we don't want to give something to something like Care Act or Care Process and have that result in something being taken away by from another population.
Right.
Which is what happens oftentimes. We need to have the infusion of the appropriate level of resources so that we can help people at a level that actually makes a difference, not just checking off the boxes, but getting people from point A to point B in their recovery.
I agree. I think it's very difficult. I can tell you, Jim and I both, we have struggled with getting, if things are going great, a doctor comes in or they leave, or they'll reduce medications And the family has no clue what's going on, because if they're not under the LPS, you don't know. And you're wondering, why are they doing that? What's going on? You have no clue, no clue. And those are there's so many, just things that don't connect from one spot to the other. So if you guys have a list and you say, this is what we need, and Connie, I love your presentation on care process, but I don't know where you're going to get the person out. That's my concern.
Yeah.
So
So thank you. We do have 2 raised hands. I did see Shirley Jones. I don't know if they got their question answered or they're unmuted now.
Yeah. Oh,
Yes, you had your hand.
yeah, I had my hand raised, right? The question I have is like, my daughter, she's getting ready to go before the courts. She's been in the hospital for a while, and the whole problem was she just wouldn't comply to the medication. And so the doctor called me and said that they did the, what is it called, the Reese with her, and now they want to do the LPS for her. And so the social worker called me on, and when I talked to him, he said what they wanted to do before they sent her home is to send her to a woman's facility for 4 weeks, so to help her get back into society. And I was just wondering, is there anything that I need to do while I'm waiting?
They're doing an LPS conservatorship hearing, is that correct?
Yes, and that's going to be this week coming up on the 25th.
Are you going to be the conservator or the public guardian, and is this in LA or what county?
This is where I live at?
What is her resident that they're going to be the conservatorship?
She's in I guess you would call it LA County, because we're in the South Bay here.
Oh, okay.
Part of it, yeah.
Okay, are you going to be the conservator or the public
Yes.
guardian? Okay.
What's the difference from the public guardian and conservator?
If they're going to try and discharge her right away, then you really want the public guardian. They fight to get them into treatment facilities. If the hospital is, now, is she being compliant with medication now or not?
They said she was. And if she's not.
Hey,
If
Gail,
she's not, go ahead.
Let me jump in here, on this one.
Go
So
for it.
Shirley, who have you been are you talking with the deputy investigator in the public guardian's
No,
office?
I haven't talked to anybody but the social worker and the psychiatrist.
Okay, so what I need you to do on Monday, get the copy of our presentation that we sent, and add the contact information on the back. There's a name there called DeAndre Davis. He's the assistant division chief now over our investigation unit. Call him and he will connect you with the investigator. If a referral has been made to our office, then there is an investigator assigned, and they need to talk to you before the court hearing on Friday.
Okay.
Okay?
Okay.
And they'll
DeAndre,
walk you through it all.